On May 20th, 2008, we were set for a 3-day trial. Our names were not even placed on the docket. Our attorney just met with the probate judge in her chambers. Our attorney would return and state to us what the judge informed him. The judge stated that the house was already gone and that we were going to lose and that she made up her mind, all without hearing the facts and testimony. The judge did not want to have a trial. This judge also refused to let our 2 younger children, including our 17-year-old son, testify to the facts and confirm everything that we were going to present to save our family and to reiterate his father's wishes. My phone records were not submitted. I had 91 phone calls alone in the month of October from my husband. We have video and photos of my husband's interactions, showing affection toward myself and our children. None was allowed or submitted. The guardian ad litem report that showed justice in a good light was not submitted or allowed. Though I had great odds already stacked up against us, I stated to our attorney if we were going to lose, the judge is going to have to listen to what we had to say. I insisted on a trial. On May 23, 2008, in Bay County Probate Court, the judge showed up nearly an hour late, looking quite disheveled. Our attorney asked my father-in-law to admit the following: that I was indeed his son's wife. Admit on January 10, 2008, that he filed an inventory with probate court and failed to list my husband's interest in our home, a joint checking account, vested interest in an annuity plan, vested interest in a pension plan, any household goods, and personal effects. Admit that he, acting as conservator, never paid for one bankruptcy payment during the duration of his conservatorship. Admit that as of April 2008, there was $10,000 cash of my husband's assets. Admit that he understood what his duties were as of November 20th, 2007, when granted conservatorship. Admit at the time of the accident on October 26, 2007, that his son did not change his address with his employer, the DMV, or the IRS, and that his son left his family home on the day of the accident. Admit that you did not inform your son's wife and children of the automobile accident until Saturday, October 27, 2007, stating that you did not want them to create problems with the doctor. Admit that Justice was capable and made several competent medical decisions concerning the care of her father. The judge would not acknowledge Justice as to her presence on the witness stand. The judge was looking at her computer, checking her nails, looking at her shoes, looking up at the ceiling, and passing notes to the stenographer. I stated for the record my husband had an excuse for his behavior, for he had a disease. I stated further that none of them in this courtroom had any excuse for what they were doing to my family. The judge found no wrongdoings in the conservatorship as follows: no wrongdoing in not contacting us at the time of the accident. No wrongdoing in not making one payment on the bankruptcy during his duration of conservator. No wrongdoings in not filing a list of proper assets to the court as the conservator over my husband's assets. No wrongdoing in leaving us without funds from October 26, 2007 to January 2008. No wrongdoing in leaving our family without bathroom facilities for 3 days. No wrongdoing in the conservator being in contempt of court. No wrongdoing in not applying the $1,600 bonus check to the bankruptcy, which was court-ordered on November 20th, 2007. No wrongdoing in not giving us my husband's last paycheck. No wrongdoing in his refusal to cooperate with us. No wrongdoing for being in breach of his fiduciary duties. No wrongdoings in every action that my in-laws inflicted upon us. The judge found complete no wrongdoings. The judge's ruling for not giving Justice conservatorship? The judge stated Justice had emotional ties to her family and that she would feel a need to care for them. The judge then gave her reasons as to the removal of Justice as co-guardian over her father, and they are as follows. Next video, please.